What would prompt the defense lawyer to start negotiating with you and your attorney on your medical malpractice case? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So there are three key reasons why a defense attorney might start negotiating with you and your attorney. The first reason is that you can show that there is liability against the doctor whom you have sued, meaning that you can show that you are slightly more likely right than wrong, that the doctor violated the basic standards of medical care. That's one reason. The second reason, the second reason is that you can show that whatever wrongdoing the doctor did was a cause of your injury. We don't have to show it is the cause or the only cause. We only have to show that it is a cause, because there could be multiple causes. Again, if we can show that we are slightly more likely right than wrong, that there is a cause, a connection, a link, a bridge between the carelessness by the doctor whom you have sued and your injury, that may be the second reason, the second reason why the defense may want to negotiate with you and your attorney. The third reason is that you may be able to show that you have, in fact, significant damages and injuries as a result of your doctor's carelessness. Any one of those three things may prompt the defense to begin negotiating. Now, if you have more than one, if you have two of those things, that may be more of an incentive for them to try and negotiate. If you're able to show all three, 1, 2, 3. If you have all three elements, now they may have even more of an incentive to try and negotiate with you. Why? Because they may come to the conclusion that they don't have a defense, or they may come to the conclusion that your case is stronger than their defense. And in that instance, that may prompt them to begin negotiating, so that now you can have an open dialogue about the value of your injuries. Then you can also have a conversation about who is more responsible for your injuries. Is it the doctor whom you have sued? Is it the doctor who's not involved in the case? Is it you, the patient, who's also partially at fault? And that's a very interesting conversation to have. So, what's going to prompt the defense to want to pick up the phone and try and negotiate? Any one of those three elements that we talked about. Plus, if you happen to have two, even better. If you're able to show three, that's the best. Because now you have all the ammunition necessary in order to go all the way to trial, so that you can put on your medical experts, so you can put on your witnesses, your testimony. And then if the defense refuses to negotiate and they say, hey, listen, we want a jury to make a decision on this, fine, let's have a jury decide whether we are slightly more likely right than wrong. And if we are, then it will be up to the jury to decide how much compensation you are to receive for all the harms and losses and damages that you incurred, all because of the doctor's carelessness. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I do understand that you're watching this video likely because you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit, but are thinking about bringing a case and still have questions that need to be answered, then I invite you to pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.